Qiao is a professor of the City University of Hong Kong School of Law. He's also the joint editor-in-chief of the Chinese Journal of Comparative Law, published by the Oxford University Press. Now, Professor Liu teaches and researches in a wide range of business-related common law and Chinese law topics, including contract law, commercial law, unjust enrichment, international commercial law, financial transactions, with a particular interest in comparative study of Chinese and Anglo-Australia private law. Now, he is a very accomplished academic. He has published widely in the above areas, including over 50 books and articles. Professor Liu.
Thank you, Chair. It's an honor to be here, and also thank the conference organizers, particularly Professor Wolf, for the kind invitation. And I also want to take this opportunity to say that I would very much appreciate if you decide to submit your papers to the Chinese Journal of Comparative Law. You are very much welcome. Today, my presentation is entitled Unjust Enrichment in Chinese Courts, because I anticipate there is another presentation, possibly on a more comprehensive scale on this topic. So I only plan to do a very brief overview before I go into a particular question. So I will still stick to my plan. Overview. What's the position of Chinese law on unjust enrichment? Now, I think everyone will know that China has just passed the civil code. The civil code will take effect from the beginning of next year. But the civil code has made a substantial improvement or change to the law of unjust enrichment by introducing four new provisions. So in total, if we look at the civil code, there are 5 provisions on unjust enrichment. Article 122 is a general provision under which you can make a general claim for restitution when there is unjust enrichment. And then the bulk of the law was is provided under Book 3, Contract, Part 3, Quasi-Contract. A very fancy and strange concept to appear in Chinese Civil Code. Chapter 29, Unjust Enrichment. Now, 985, the first half of this provision, replicates what is contained in the general provision under Article 122. But 985 also provides for 3 defenses. The other 3 provisions provide for the extent of liability, the liability of restitution in the event of unjust enrichment. So these are all new provisions which are very interesting, but because they are very new, we don't yet have any case on what's the meaning of these provisions and how they are going to be applied by the courts. We have no idea yet, but we will see because they are very important. Now, if we take our eyes off legislative provisions, if we look at the judicial practice, and then there are a number of judicial interpretations, which is basically in China means law, judicial interpretations or judicial documents issued by Supreme People's Court, which provides for some matters relating to unjust enrichment. The most important of which is Article 131 of a very old judicial interpretation. That's the Supreme People's Court 1987 opinion on the 1986 General Principle of Civil Law, which provides for the extent of restitution. So it's about remedy or liability. But what is more interesting or significant is not these legislative or semi-legislative provisions. Rather, it is the judicial practice. It is how Chinese courts decide, apply the rules, and decide cases. Now, the importance of this area of law can be seen if we do a simple count of cases on the official China Judgment Online website. Now, as of 24th June, I counted the number of cases entitled Unjust Enrichment Disputes. Now, we know that Supreme People's Court assign a title, which is a category of dispute to every case. This is a lawful indication about what is the legal question, legal issue is. However, it is not conclusive. So an unjust enrichment case may yet involve contractual disputes. But anyway, it's a rough guide. It's almost 300,000 cases unjust enrichment. How do we understand this figure? Now we need to compare this number of cases with some other civil disputes categories. Now we don't compare it to contract or tort because contract or tort are too big. It's like more than 1 million. Okay, there is no comparison. However, we can compare unjust enrichment cases to other traditional and big areas, fields, like company cases. Unjust enrichment cases are slightly more than company cases, and much more than maritime cases and cases on negotiable gesture. So actually, unjust enrichment is much more important than negotiable gesture cases. Okay, even though these two are standing together as two little brothers in the civil code, but actually unjust enrichment is much more important. So what can we do with these cases? Now, what I can say is that with these cases, we can only look at the most important of these cases. How do we decide which cases are important? Now, obviously, normally cases decided by the Supreme People's Court, Higher People's Court are regarded as more important. And also there are cases published by the Supreme People's Court in its official journal called Gazeta. So Gazeta cases are widely regarded as most important. So if we look at these most important cases, this will make our research feasible, manageable, when nobody can study 300,000 cases. So what can we get? We can get, I think, this is a very fertile field. However, what we have is basically an unruly mass. There is no order, no organization, too much inconsistency. So what I propose to do in my paper is to reintroduce some order into this group of cases. So from beginning, what we can see from these cases is one thing is clear. All the courts, all the judges, they all agreed that there are 4 elements of unjust enrichment claim. These are the 4 elements. They look very simple. Okay, defendant is enriched. The enrichment is obtained without legal ground. Plaintiff suffers a loss, and the loss is caused by the defendant's enrichment. Then there is a claim in unjust enrichment. And now, after civil code, this claim will be subject to recognized defenses. But then in my presentation, I think I will focus on this fundamental question. In China, do we have an unjust enrichment law or unjustified enrichment law? Now, we should start from the civil code provision, Article 122, or you can look at 985, which are almost identical. You can see the provision makes reference to both unjustified, that's without legal ground, and also unjust benefits. Okay? Now, so we cannot see from this provision what's the true intention of the lawmakers is. Does unjust simply mean without legal ground? We don't know. We need to wait for the courts to tell us what interpretation they will place on this provision. Why is this difference so important? Well, it's very important because unjust means has a much broader meaning than unjustified. Unjust may mean unfair, improper, inequitable, as you can see from previous presentations. And most important of all, unjust will include cases where there is a failure of purpose, even though the legal ground is there. But unjustified has a more restrictive meaning. It simply only means that there is no legal ground. And a legal ground in the Chinese context is understood to be either a contract. Now, whether the contract must be a valid contract is another question, or a provision of law. Okay, so does Chinese law adopt the German absence of basis model, or is it closer to the English unjust factors model? Now, if we look at the provision, it seems to indicate that there is a genuine German model in place. However, the reference to unjust leaves the question open. And actually, we can find in some cases, the courts use unjust enrichment to redress what they perceive as an unfair or unjust result. So that's a departure from the German absence of basis model. We will see some examples. Well, maybe Chinese law is similar to English law on this point, but there is no list of unjust factors in Chinese law. It's what we have is a broad concept of unjust, unfairness, on which the judges have a great deal of discretion to say what that means. So what we can do is we can do a survey of the most important cases. Now here we look at the Supreme People Court Gazeta cases, and we find 4 cases. And we can see that a majority of cases adopts the unjustified view. Only one single case seems to indicate support for the unjust view. So essentially, what these cases was deciding was where there was a contract or settlement agreement between 2 of the parties, and one party agreed under this contract or agreement to pay some money in return for something valuable. It might be abandonment of a legal claim. It might be something else. After this, one of the parties say, I paid too much. So can I claim unjust enrichment from the other party? Now, in 3 of these cases, the court said, no, you can't. There is a valid contract. There is a valid agreement. You can't do that. So this is clearly adoption of unjustified view. There is a legal ground, and we don't care about whether it's fair or not. However, in one of these cases, that's the last one, the warehouse man embezzled some goods and resold the goods for money, okay? And then the employer and the warehouse man reached a settlement agreement under which the warehouse man paid some money to the employer as compensation. And the employer gave up the legal claim against the warehouse man. But after that, the warehouse man said, actually, I paid too much. The employer suffered a loss which is smaller in amount than my payment. The court said, well, you didn't prove that. You failed because you failed to prove that the employer's loss was lower than your payment. So the implication here is, had the employee successfully proved the employer's loss was less than the money paid, the value of the money paid, then the employee would be able to claim unjust enrichment from the employer, despite the fact that there was a valid and effective settlement agreement between the parties. That's a very orienting sign, I must say. But that's, of course, we can see that's a Chinese version of how unjust view could be played out. Next, I will very briefly introduce what is in practice a very important and debated issue, which also indicates in some degree that maybe unjustified view should be adopted. That concerns whether the duty to return benefits based on unjust enrichment, based on after the contract is terminated, is based on unjust enrichment or contract law. Now, if we look at the Article 566 of the Civil Code, it provides that all benefits should be returned when the contract is terminated. So this is very similar to the German laws, German Civil Code and the Japanese Civil Code. And there is a separate provision for restitution of property or compensation for its value when the contract is void, avoided, rescinded. Okay, so we have 2 separate provisions, and these 2 provisions use different wordings. So do the lawmakers intend? These are two different types of claim. We don't know. We don't know. If we follow the German model, we know the German model, then restitution of benefits under a terminated contract is not based on unjust enrichment. It's a contractual claim. It's a claim based on contract law. It's a special type of contract. But does Chinese law adopt this German model? Well, you would think so, because all the experts engaged in the drafting, they are trained in German law. However, this is not definite answer, because the lawmakers, the civil code does not make this point clear. We don't know yet. We have to find out. And one of the questions we can ask is whether benefits transferred under the contract are they without legal ground when the contract is terminated. So when the contract is terminated, is it the same as the contract is void or avoided? Is there still a legal ground to support the transfer of property under the contract before the termination? So we can see that this has some connection with unjustified or unjust question. But in practice, the real interesting stuff is that this will affect the order of claim in insolvency proceedings. So we will move on to that very important this issue. Now, the whole matter or question starts from provision in enterprise insolvency law, sometimes known as enterprise bankruptcy law, which means the same thing. Article 42.3, which says the insolvent's obligation to give up unjust enrichment that arises after the commencement of the insolvency proceedings constitutes a common interest debt. It's a common interest debt, and therefore it takes precedency over its obligation to pay employees' wages, remunerations, tax, social security, and of course, to unsecured creditors' claims. So it's a privileged claim, unjust enrichment, if it arises after insolvency proceedings. So that's so important. It's so important to have your claim classified as an unjust enrichment claim. If it's a contractual claim, you get nothing. If it's an unjust enrichment claim, you can get everything. So in two types of cases, the Supreme People's Court has said very firmly that this is the case. When a claim for the return of benefits under a terminated contract is an unjust enrichment claim, and therefore has a privileged status in insolvency proceedings. So one type of case is a lease contract. Under the non-time lease contract, the lessee has paid all the rents beforehand, and then the lessor went insolvent. Okay, and then the lessee, of course, had unjust enrichment claim against the lessor because the administrator decided to terminate the contract. The court said this claim for unjust enrichment is as long as it is for rents which will come due after the commencement of the insolvency proceedings. They should be classified as a privileged common interest debt, and it will be satisfied ahead of basically all other claims. Another example is that when you buy off-plan apartments, you paid some money, and then the property developer went bankrupt or insolvent. You can reclaim the money back ahead of all the creditors. Okay, so that's a very interesting issue, and we can see how this what is theoretical debate under Chinese civil law could be played out as a very significant practical issue. Another related point I want to very briefly introduce is whether Chinese law adopted the distinction between enrichment by performance and enrichment in another way. Now, the general provision 985 does not make this distinction. However, Chinese scholars, they are predominantly, the predominant view of the Chinese scholars is that there is such a distinction. They all support Professor Wang Zijian's view, and Wang Zijian is a Taiwanese scholar, and he is expressing a view under a provision which is very much similar to the to the provision under Chinese civil code in Taiwan. Okay, so under the Taiwanese civil code, the distinction was also not recognized by the lawmakers. But still, Professor Wang Zijian says there should be a distinction, it should be recognized in practice. Now, if we turn to judicial practice, the distinction has been recognized in some cases, but it is far from universal. Reasons for the distinction, well, there are a number of reasons. I just want to highlight one of them. That is, the proof of without legal ground is different depending on whether it's a in performance case or other than performance case. Particularly, there is a great number of cases in which the court basically says that if it's a performance case, that's enrichment by performance, it is all for the plaintiff to prove there is no legal ground, which can be very difficult. You prove that all the parties obtaining benefit has no legal basis. It can be difficult. But if it's an enrichment case in another way, then the defendant should have the burden of proof. The defendant should prove he actually has a legal basis, legal ground to obtain and keep the benefits. So that's pretty much one of the questions I want to share with you. And from this, I can draw some tentative conclusions, which are not necessarily very, might not be very helpful at this stage. But okay, so basically China is developing, I think it's a unique law of unjust enrichment. Well, some will say this is based on German model, but there is no necessity that Chinese law has to develop in a path which is similar to the German law. The German experience can be very useful, very valuable, but there is no necessity that the Chinese law will be developed in the same way. The next one is that Chinese code has introduced some new provisions, but still the overall framework is too abstract, too broad. So Chinese courts, especially Supreme People's Court, will play a very significant role in developing the law of unjust enrichment in China. And also, there are a number of points I want to say that is that Chinese courts should refrain from adopting the unjust view. It should adopt a more disciplined view of unjustified enrichment. And also, I think the distinction between enrichment by performance and in another way should be recognized in China. Relating to the privileged status of unjust enrichment claims in insolvency proceedings, I think there should be a fuller consideration of this issue by the courts in future cases. So that's all I have to say, and thank you for your attention.
Well, thank you so much, Liu Qiao, for walking us through this, in your word, this unruly world of PRC law on unjust enrichment. I think I have given it a lot more order than it otherwise appears. Thank you so much for this.